let's get into the Sidney Powell lawsuits. She filed now in Georgia and Michigan, correct?
I believe so, yes.
Now, and then it's going to bring me into this Raffensperger settlement agreement that I messaged you over before, but I think we've already seen it before in Georgia. Which, if people don't know about it, it's going to really blow your minds in terms of Raffensperger now having his own skin in the game and his own tushy potentially on the line for what he did, and now it's coming to light. Overall, what do you think of Sidney Powell's lawsuit? Is it what was promised? Do you take back anything you said last week? Do you want to clarify anything you said last week?
So, I think there's different components to it. She took all of the different information that was out there and aggregated it together. So she included Matt Brainerd's information. She included statistical anomalous information, included affidavits that Georgia Republicans were gathering on a local basis, that the Michigan lawsuit guy had put together, aggregated all of that together, aggregated prior complaints about Dominion, and included all of that, added one or two components of her own. And I think did a good job in terms of, in summary fashion, of including all of the potential allegations and issues. The potential weaknesses with the claim are, one, is filing in federal court, and I'm not sure why she did that. The reason is at this stage, once it's post certification, the place to file is in state court, because usually you have election contest remedies, and she actually added an election contest to the claim, but she filed it in federal court. The limitation there is, in Georgia law, election contests really appear to you can only legally file them in state court. They have these expedited remedies. And if you don't file it in time in state court, you may be out of time and never be able to contest the election. And so by filing in federal court may create a problem for her, in which she never gets a chance to have the election contest adjudicated. The second is she has the same issue of standing that Lynn Wood had. And Lynn Wood is part of the Sidney Powell suit, too. He's one of the lawyers, not one of the parties. And now she has the electors. She has many of Trump's electors from Georgia as part of the suit. And theoretically, they're the candidate, and they can step in the shoes of the candidate, because technically they are kind of the candidate, legally, technically. And that may get them past certain standing issues. They drew a decent judge who initially granted an injunction and then withdrew the request within an hour because of standing issues. So, and because of who they sued. They didn't sue all the counties.
Someone messaged me that, and they say, how does that possibly happen? The judge issues a judgment. Was it on appeal? Was it on a motion for reconsideration? Or did the judge just do it of his or her own volition?
So Sidney Powell requested a preliminary injunction on grounds that some counties were deleting computer file records pertinent to their claims. So, but the Secretary of State came in and made 2 points. One, that they don't have standing to sue based on what the other federal court judge had said in Lynn Wood's case. And second, that they had not sued the counties, and that was all in the custody of the counties, and they couldn't do anything. But by the way, frankly, either way, why is the Secretary of State coming up with excuses for the county to destroy evidence and information? This guy is such a fraud, such a phony, such a fake. His representatives lied to me for 2 weeks. And by the way, his lawyers were supposed to be Trump's campaign's lawyers. That's why Trump's campaign's lawyers were lying to Trump's campaign right after the election. So that's the kind of scams we're talking about here. So, that's how the judge reversed it. The problem is that those are two big hurdles. If you want to make sure you have complete control over the election process in Georgia, you have to sue all of the counties. In an election contest, you can just sue the Secretary of State because that's the certifying official, and the state court judge will grant you immediate discovery as to everything else. You don't have to sue all the counties. But if you want to enjoin the counties in a federal suit, you got to add. Now, that's a drag because that's 159 counties. And if you're sued by election board member, that's whatever, it's serving 800, 900 people. So, that's what, $400 a pop sometimes for service of process. So that can get expensive. But I think some of this is reflective that there's still no election lawyer involved. So there's almost no election lawyer involved in any of Trump's cases. So it's a major hurdle. And it's how they get behind the 8 ball in the Pennsylvania. They make it easy for the Pennsylvania federal court to take pot shots at him because of how they file the case. They make it easy in other places because they don't know quite I mean, for example, the Trump campaign, I don't believe did file a timely Pennsylvania contest. Luckily, I believe some voters did, but I don't think the Trump campaign did, because my guess is Rudy doesn't even know about that. So what Rudy is good at is the PR side. He's good at the hearings, those legislative hearings, talking on TV. That should have been his role, not running the actual litigation side. And Sidney Powell, God bless, you really needed to incorporate an election contest or election lawyer into the case to say, here's, if you're going to go this procedurally, you can file your federal civil rights actions in state court, and you file your election contest where you have broad remedies, but you have to be ready to rock. You got to be, like I said, ready to go in 5 days, typically, in Georgia. So those are the weaknesses to the case. I think the public reaction, and law Twitter was always going to be hypercritical, but in terms of evidence, I don't think she produced any new evidence that necessarily reached, Kraken standards. Now sometimes people do that. They oversell to get attention, thinking that's what's necessary to get attention in the first place. So that may have been her strategic objective. But I didn't see new evidence that suggested algorithmic fraud is at the source of this election. Doesn't mean that such evidence can't exist. I just didn't see it in the complaint.
And see, that was my bottom line takeaway as well, is in the absence of those press conferences and the public statements prior to releasing the lawsuit would read pretty well. I mean, I don't care about the typos. I think a lot of people are making hay of the typos. Some of them are just formatting or condensing issues when you turn a document into a digital document. But I would say in the absence of those, in the absence of the hype, the lawsuit is decent on the constitutional questions. It's a little weak on the evidentiary issues relating to Dominion and Venezuela and everything. And so if it were just the lawsuits, it would be one thing. It was just specifically, in light of those comments, the affirmations that I took to be very convincing that there's determinate evidence, not old affidavits and not expert evidence. And I've looked through it. I haven't done a video on it. It's too much almost. And, a lot of other people are covering it. A lot of those affidavits from the experts, they're opinion affidavits. They're not firsthand, I coded this and this is how it's coded. It's not firsthand, this is what happened at Dominion offices. They are, in my opinion, it's likely that it's fraught for I could hack in 7 minutes with a screwdriver, not I did hack in 7 minutes with a screwdriver. So that's where I think it's problematic in light of the previous statements that were being made. It's sort of a letdown for a lot of the people who had this faith that there was going to be I don't know what the analogy is, but like this golden hammer that was going to smash everything open. It didn't happen. Some of the good arguments, and if anybody doesn't know this, Georgia specifically, one of the strongest arguments, it was covered in another lawsuit, was this confidential settlement agreement that Raffensperger entered into pre-election with Democrat entities. I don't know what they were. They're political parties or they're political entities. A settlement agreement that I think was confidential that basically dictated how absentee ballots were going to be treated and how signature matches were going to be treated, and created such an onerous, unreasonable cross-check for signatures. They basically made cross-checking signatures impossible in Georgia. And it's something like, somebody's going to review it. If one person thinks that the signatures don't match, they're going to get two other people. They're going to convene a majority of the two of them to determine if it's sufficiently accurate to match. And I guarantee that never happened in any of them, which probably explains how there was no throwing out of any absentee ballots, the vast majority of which we knew were going to come in for Biden. So that's the strongest thing in that lawsuit, in my humble opinion. If people don't know about it, just look up the Raffensperger secret settlement agreement. I mean, Robert, how does that happen? How does a settlement agreement affect protocol for an election?
Well, there's two different issues there. By the way, the Trump judge also dismissed Lynn Wood's claim on that on laches grounds. Isn't that something? Why didn't you just rush to sue even when you didn't know about the problem? I mean, this is the kind of another Trump appointee, another Federalist Society guy, a guy I knew from his tax division days, a Rosenstein type. And so not a surprise, Rosenstein was also the tax division, also Federalist Society member. I'm going to keep lecturing on that for years because we need to break up their monopoly, folks. But so they did this all across the country. Georgia was not the only one. Beginning in spring, Mark Elias and aligned, affiliated, associated Democratic front groups waged a legal war on pretty much all the states, even states they didn't think they were going to win, like Tennessee, saying to not enforce signature match checks and to allow notice and cure opportunities. And so they were filing suits in some cases. They were threatening suits in other cases. They got the Michigan Secretary of State to issue a preposterous signature match set of standards. And by the way, we have standards out there. We have standards from Oregon. We have standards from Colorado. There's video training they do by the Georgia Bureau of Investigation, according to the Secretary of State. Instead, they scrapped all those standards. And like they have the Michigan Secretary of State to say that if your signature looks exactly like it normally does, then that's probably a match. But if it looks completely radically different, in other words, you went from a cursive signature to a block print, first grader signature, they said maybe that's still a match. They said if you went from a long cursive signature to one line, maybe that's still a match. Those are just questionable. That's how absurd they intimidated every election official in the country into not enforcing signature match standards. That's how they were able to increase the vote totals everywhere, because they wanted no anomalies. They didn't want Tennessee showing totally different absentee ballot rejection rates than Georgia. So that's why they threatened everybody. They did it mostly behind the scenes. Some of the cases actually became public. Now, this is where Trump's campaign legal team was asleep at the wheel and, in my view, engaged in massive legal malpractice. They should have been challenging this. They should have been contesting this, and most of them were not. They were, in some cases, they weren't meaningfully aware. Now, I think that settlement was not fully a secret settlement. That suit was public. They just weren't monitoring and tracking the suits the way Mark Elias does for the Democratic Party. And they don't have a coordinated approach. Many of the people in the legal world don't like Trump, even if they're nominally Republican. The few that do are often conflicted because they represent the Secretary of State. I mean, that was the problem. The people representing the Secretary of State are purportedly Trump's campaign people. So do you think they're going to expose their other client, their paying client, Secretary of State, their future paying client? I mean, they had a conflict in such a way they couldn't be involved. But they were pitching people, don't worry, because we have these relationships, it will help you. They haven't helped any. All those folks Trump has got legal malpractice claims against a lot of people if he ever wants to bring them.
This was something I was thinking, and now in hindsight, appreciating when they were talking about amassing an army of lawyers for the Democrats were in the months leading up to the election. Now I'm really appreciating what it meant is that they filed these lawsuits. The settlement agreement, I was just checking to see if the word confidential was in it. Doesn't seem to be in it, so it probably wasn't confidential, but I suspect it wasn't well known or widely known that they basically, in a settlement, to which Raffensperger was, a party, said, we're going to create such an onerous cross-checking of signatures that it's basically not going to happen in real time or if ever. And now Raffensperger, who has his name on that settlement, is somehow going to has a vested interest in protecting the outcome, because otherwise it looks like he contributed to the outcome, notwithstanding his political affiliation.
And that isn't all he did. He partnered with the ACLU to help, quote, monitor the signature match process. He partnered with various Stacey Abrams groups to help send out massive ballots in the primary to increase ballot primary participation. He allowed for drop boxes to be used throughout the state, so you'd have no meaningful chain of custody of ballots. So mistake after when issues rose about whether Dominion was pre-printing ballots that were not being spoiled that could be replace future ballots, he took no corrective action. And now he has refused to do the audit that he promised the whole state he would do. Go back to look at CBS, look at his name and look up, recanvass, audit, and recount. He said he was going to do all three at the same time. He lied to the whole state. So the bottom line is he is neck deep with a lot of these people. The lieutenant governor's neck deep with them. The governor's neck deep with them. The Purdue political machine has not been doing anything to help Trump, even though one of them has a cabinet position and the other one is running for Senate in the runoff. So it's Georgia's Republican Party, institutional party, is a useless institutional party. Now, the party people are good. It's the people who hold elected office are bad. That's the problem.
Okay, here we got Craig Lino says, is there time for Sidney to file injunctions against each county before the evidence on the machines are wiped? Can there be an adverse presumption of fraud based on spoliation of evidence? So one of the conclusions that Sidney is seeking in her lawsuits, which we'll see if any judge is going to grant it, is, what do we call it, seizing or preserving the voting machines or the information on them. Going to the question, is there time? What are the chances the judges grant that?
I mean, here's the big problem. It's highly likely all of her federal cases will be dismissed for lack of standing. So it's going to be very hard to overcome that. That's where they've been going. My view was it was worth trying the federal courts before you could even get to an election contest stage pre-certification. But one, it was, you have state remedies that are better and broader. Number two, the federal courts have proven now they're useless. So you can always get to the U.S. Supreme Court through the state court system. You don't need the federal court system to get there. So once it was becoming clear that federal district courts were going to do Pontius Pilate and federal appellate courts were going to be arrogant, condescending versions of Pontius Pilate, it was time to skip those. Just go to state court, start attacking in state court. Now because you have a lot of state courts where the local court might be fair, like you got in Pennsylvania. You got a very fair ruling. You got some Supreme Courts in several of these states where you've got some smart judges on there that might take meaningful remedy, that are not as sort of Pontius Pilate corrupted the way the federal courts have institutionally become over time because of too many of these Federalist Society types. A lot of these state court judges are not Federalist Society types. Notice the difference.
Oh, and I promised someone earlier you would remind everyone what your issue is with the Federalist Society. Some people who are first-time watchers may not know why you take issue with them.
The Federalist Society's developed a monopoly on appointments to power, particularly in the federal system on the right, so that almost nobody gets approved for a position of power unless you're in the Federalist Society. But the Federalist Society promotes political bootlickers and establishment cowards. And so the only people they'll come to fight for are Bushes. The only people they'll come to fight for are establishment types. They will often cover up for the system. That's, how is Christopher Wray, head of the FBI, has done nothing whatsoever to deal with the problems from Spygate, to deal with the problems from Ukrainegate, to deal with the problems of all these illicit ballot activities likely having taken place right under his nose while he was promising to monitor it. He was more concerned with Russian hacking. He was more concerned, which has always been a bugaboo. He was more concerned with alt-right rising from somewhere and being this huge group, and there's maybe 200 of them in the whole country. So he was busy propagating and pushing liberal talking points because the Federalist Society has a bunch of traitors in it. So there are people that you should never have one group monopolize federal appointments to legal positions of power. That's always a bad idea. Number two, this particular group has disproportionately promoted terrible people. About half of their choice, the people they recommend, will be awful and will not be loyal, at least not to any kind of populist or true constitutional kind of independent liberties-oriented view of the world. They're establishment corporate types. Now, if you're the Koch brothers, you love the Federalist Society because they'll probably even come to protect big tech when the time comes. They love to gut antitrust law when the time comes. Just look at what most of their work is and look at the fingerprints of who is on there. And no better example than this election. 4 different Federalist Society judges, 3 of them Trump appointees, all of them refusing to take any remedial action in the election contest and usually taking pot shots at Trump in the process. What does that tell you about who these people are?
Okay, now let me think. What do we do here? There was one thing in the Georgia. So we had the Georgia settlement, the Georgia lawsuit, the conclusions, likelihood of where it's going to go. Michigan, it's the same basic suit coming out of Michigan. There's more affidavit evidence that's accessible online.
Dismissal is likely there too, though the supplemental jurisdiction claim may hold. But if it doesn't, then the same problem is present. Now, the Michigan Supreme Court judges in concurrence made good points about the constitutional right to audit in Michigan. And so more people should that are in Michigan try to follow up on that. There is the suit that was part of that I believe is still going to be going on. It's just the emergency injunctive relief was denied. But that meaningful audit procedure should be enforced and interpreted. And so hopefully that at least election reform comes out of it. But I believe an election contest will be filed by the Trump campaign in Michigan. I believe an election contest of a form of it has been filed with the original petition with the Wisconsin Supreme Court. That's going to move forward. Trump campaign is going to be filing challenges to a lot of these ballots where they let people vote that did not meet the legal standard in Wisconsin. You're going to see a common pattern. A bunch of people voted who did not have a lawful right to vote, either by the manner they voted or because they weren't even lawfully registered in the first place, or they were out of state or something else. And that's going to aggregate into a narrative in all of these jurisdictions, all of which could go up to the U.S. Supreme Court. And ultimately, it's going to be do the state legislature. To give people a history example, in 1876, there's nothing that prohibits the state legislators from certifying to Congress their own electors because they have doubts about who won the election, or they believe Trump actually did win an honest election. There's nothing that prohibits that. 1876, that's what happened. And what you had was back then, the election officials who certified the ballot were mostly controlled by the Republicans, the canvassers in these various states. And so they certified for the Republican candidate. The Democratic state legislatures got together and they said, nah, we're going to have our own electors and we're going to send them up. And so what happened is Congress got two sets of electors from 4 different states. So nothing prohibits the state legislatures from doing this all on their own accord. There's federal law interpretation that says you can rely on the governor rather than the state legislature, but that raises constitutional questions because the electors clause says, no, it's the state legislatures that choose. And the U.S. Supreme Court, both in 1892 and again in 2000, said that the state legislatures can use their power or retract their power whenever they want, that it's plenary and it's not subject to judicial review. Yeah, all of them can do that. In addition, the House and the Senate can join and object. So these remedies and the Supreme Court can get involved. The 3 places where Trump should have allies on paper can all take remedial action. The question is, and they have beyond the question earlier about December 8th, December 14th. The Electoral College meets on December 14th, but there actually isn't certification of the electors until January 6th. So really, that's the drop dead date. It's what Congress certifies. And in my view, the real drop dead date's not till January 20th. It's not till Inauguration Day. To give an example, in 1876, back when Inauguration Day was in March, they didn't decide the issue until 48 hours before Inauguration Day.
Yeah, but some people are pointing out that, it's a different information age now. You have the media having set up an expectation and 75 million people dancing in the streets. That'll change the dynamic much more in terms of what people might be, politicians might be willing to deal with in terms of blowback if they actually certify the electors in a way that the state did not turn.
But what's their blowback if they certify an election that their own voters think is fraudulent?
That's I can't answer that question, but a lot of people are asking it in the chat. What do we got here? We got Cleopatra's in the house. Hey, Viva and Barnes, I'm very late and we'll have to catch up tomorrow. No matter what happens, I won't give up hope until it's over. Cleopatra, good to see you. And thank you very much. Now, it then sort of brings us to this question. Tanja Pisler says, Barnes, if you were President Trump, how would you play it? What's the best third act?
Honestly, the best third act is to set up that the election was stolen, allow the institution, push it through every institutional remedy you have, let them fail you. And if they do, simply use that as ammunition to build a real independent coalition of your own allied individuals and officials, and use the next 4 years to do what Andrew Jackson did between 1824 and 1828, and build a movement that is far more impactful. Build a movement that isn't infiltrated easily by the QAnon types that take things in a direction that's different than I think is productive. Build or the corrupt insiders that are undermining you at every turn. That the only thing they have for you when your back is turned is a knife. That you have the people that have your back, not the people that want to put a knife in your back. Build an independent media army. I mean, for example, almost all the tools of modern campaigning, Andrew Jackson invented for 1828. Almost all the things that we associate with modern campaigns in terms of paraphernalia, mailers, you name it, Andrew Jackson created out of thin air. So he created because he knew he had to. He had to find new means to reach people, new means to communicate to people, new means to organize people, and build a real network of deep organizational ties. And that's how it happened. That's also how 1776 happened. That's Kevin Phelps' book, 1775, The Year of Revolution, about how 1775 is what really created the revolution, even more so than 1776. It laid the groundwork for it. Unruly Americans, about how the Bill of Rights was amended by the public reacting and organizing. So often it's the case that you have to lose something to win something big. So that's where people think I'm not giving up or anything else. There's still a chance, and on law and on facts, he should prevail. But I'm saying be prepared that doesn't happen, but don't use the defeat, if defeat is what occurs, as a permanent setback. Use it as an opportunity. Do what Trump says. But I can personally assure people Trump's mindset is very much a positive one. It is not a negative one at all. All these articles you're reading about, he's mad and he's angry and he's more. None of that is true. Just the opposite. Shockingly optimistic, frankly. Because his view is, I'm going to march forward. Maybe the system does it right. Maybe it doesn't. If it doesn't, I'm going to march forward in 4 years. And we're going to build something real strong that lasts, that's independent. And I'm going to have fun doing it. And you add Trump TV, you add a real Trump organization, you build independent, you support and prop up independent internet social media sites, then you can help build the machine that can outlast and that be much, much stronger in 4 years than frankly it would be if he wins power now.
Okay, amazing. Now, this is also a comment I've been seeing a lot of, claims regarding a German server that was seized. And there were some other comments to that effect, but are you familiar with this discussion about servers that were seized in Germany that might relate to this election?
Highly unlikely for it to be true. And my problem with making those claims is you really better have some evidentiary background. Because take, for example, Powell files suit, initially gets relief from the federal court. An hour later, he reverses himself. That's a sign of a federal court that was probably leaning your direction. And then the opposite side points out big flaws in the case, and he all of a sudden pulls back. And what may happen is the evidentiary weak links will be highlighted, while the evidentiary strengths will be buried. And if you lose the confidence of a judge when you're asking him to do something extraordinary for a judge, it shouldn't be extraordinary, but it is in their mindset. These are cautious actors by nature. These are not the most, path blazing people in the world. That's the exception, not the norm. And so you can lose them. This is why, every lawyer will say it's not what you know, it's not what you think you know, it's what you can prove. So focus on the most provable claims, and you only take a Hail Mary long shot with something you may not be able to prove when it's your only option, when it's your only alternative. If you're Johnny Cochran in the opening statement, you figure you need to get away with 6 other people that might have done the killing in OJ's case. That's when you do it, when you know that you're not going to be able to have evidence down the road. But if you have evidence, you focus on that evidence, not on things that are going to be tough to substantiate. And I've seen other people that are pro-Trump that are very data-connected individuals or connected into that world, and they're coming back saying these stories are not true. The server story never, I seriously doubt there'll ever be proof of it, put it that way. And it smacks of QAnon. So the other thing is, the people that are suspected of being behind QAnon, which is Ron Watkins and his father, Jim, he reads like a character out of a James Elroy book of a disinformation campaign. He was in the Army and was early on involved in IT work, and then decides to move to the Philippines to help set up a Japanese porn site, and stays in the Philippines. It partially does pig farming and stuff like that. And there's real reason to believe a lot of people that have followed QAnon believe he's the source of it. I'm sorry, I don't trust that information. I don't trust it to be reliable. I definitely don't trust it to be provable, especially when it often has the hallmarks of disinformation and has the hallmarks of things that will discredit the legitimate evidentiary claims that she clearly has.